last week's 7-2 decision by the U.S. Supreme Court in Masterpiece Cakeshop Ltd. The Colorado Civil Rights Commission was a huge victory for religious freedom at a time when that bedrock First Amendment right is under attack by creeping secularism. While the lay media have avoided portraying it in such conclusive terms, the ruling's significance lies in its rejection of the oft-heard, categorical assertion that the free exercise of religion doesn't apply to those operating businesses of public accommodation. Jack Phillips, an expert baker, has owned Masterpiece Cakeshop Ltd. in Lakewood, Colorado, a suburb of Denver, for 24 years. He is also a devout Christian, whose main goal in life is to be obedient to Jesus Christ and Christ's teachings in all aspects of his life. One of Phillips' religious beliefs is that God's intention for marriage from the beginning of history is that it is and should be the union of one man and one woman. Thus, he also believes that creating a wedding cake for a same-sex marriage would be the equivalent of participating in a celebration that is contrary to his deeply held religious beliefs. When Charlie Craig and Dave Mullins, a same-sex couple, entered Masterpiece Cakeshop in the summer of 2012, they informed Phillips that they wanted to order a cake for our wedding. He replied that he doesn't create wedding cakes for same-sex marriages but offered to make any other type of cake for them, as well as sell them many of the bakery's on-display items. Although there were numerous nearby bakeries willing to accommodate Craig and Mullins, they opted for confrontation, filing a complaint against Masterpiece Cakeshop and Phillips under the Colorado Anti-Discrimination Act. In addition to citing his religious-based defense, Phillips also argued that requiring him to create a cake for a same-sex wedding would violate his free speech rights by forcing him to exercise his artistic talent to express a message with which he disagreed. The commission nonetheless ruled against Phillips on both counts, ordering him to cease and desist from discriminating against same-sex couples and to participate in various remedial measures. After the Colorado courts affirmed that order, Phillips persuaded the Supreme Court to hear his appeal. Writing for the 7-judge majority, Justice Anthony Kennedy noted the hard reality that seems to have escaped partisans on both sides. This, he said, is a difficult case, for it pits the legitimate First Amendment rights of Phillips against Colorado's desire to prevent discrimination in places of public accommodation. Both of these competing interests deserved respectful consideration, Kennedy continued, something that didn't happen here because of the state commission's overt hostility toward Phillips' religious beliefs. Indeed, the record is replete with instances of such animus. As Kennedy pointed out, the behavior of one commissioner even went so far as to compare Phillips' invocation of his sincerely held religious beliefs to defenses of slavery and the Holocaust. The Supreme Court flatly condemned such hostility toward religion, in noting that the commission is charged with the solemn responsibility of fair and neutral enforcement of Colorado's anti-discrimination law, a law that protects discrimination on the basis of religion as well as sexual orientation. Although the court elected not to address Phillips's free speech claim, Justices Clarence Thomas and Neil Gorsuch did so in a concurring opinion. Underscoring what the court itself has acknowledged on other occasions, they observed that the mere fact that somebody may be morally opposed to same-sex marriage doesn't mean they're bigoted and unentitled to express a different view. They also opined that the creation of a wedding cake does, indeed, involve a type of expressive action protected by the First Amendment's free speech clause. By opting not to address that issue, the court guaranteed that it will be raised again in future litigation. After the court ruling, advocates for the same-sex couple involved, including sympathetic elements in the mainstream media, scrambled to downplay the significance of Phillips's victory. What they were actually doing, however, was engaging in damage control. While the case was pending, these same people were warning of the dire consequences that ensue if Phillips were to prevail. In fact, they were clamoring for a ruling that would categorically hold that religion has no place in the marketplace. Last week, 7 judges rejected that proposition, including liberal justices Elena Kagan and Stephen Breyer. Any way you slice it, that's a major victory for religious freedom. Email Daniel Eddy at column@danieledylaw.com. Follow him on Twitter at LegalHotshots.